Daily list, item number 1 for pronouncement of judgment.
I'll read out only operative portion. This court, on careful perusal of the impugned order, does not find any infirmity in the same, inasmuch as the respondent authority has covered the entire case of the petitioner and has reiterated that because of his inadequate grading in his ACR for the relevant period, he could not be considered for promotion. His prayer for upgradation of such entries has not been entertained, for which process this court would find no fault thereof. Be that as it may, the fact that the petitioner was granted financial upgradation in the year 2016 under the MSCP scheme, which was not denied by him, the respondent authority confirming the fact that because of the said financial upgradation by which his pay scale was equivalent to the pay scale of a Subedar GD, therefore there is no financial loss to the petitioner. It is also brought out in the course of this proceeding that the petitioner has since been promoted to the post of Subedar GD with effect from 16/4/2022. Therefore, no discrimination is found apparent as far as the petitioner is concerned. In view of the observation made here and above, this court finds that the petitioner has not been able to make out a case on merits. This petition is accordingly devoid of merit and the same is hereby dismissed.
You'll see the record given, please.
Record will be handed over to you. I have noted it down.
Please, Your Lordship. Lordship, I beg to mention item number 10, Your Lordship. Because the conducting counsel is not keeping well, Your Lordship. If this matter could come after 2 weeks, Your Lordship.
I think this is only for your, instruction of your client as
Yes,
to
Your
whether you
Lordship.
pursue with the matter or not.
Yes, Your Lordship.
As it is, it would be academic if you pursue with this matter.
Yes, I understand, Your Lordship. After 2 weeks, Your Lordship, this matter will come up.
On prayer made by the petitioner, review petitioner, list this matter up to 2 weeks.
Much obliged, Lordship.
May it please Your Lordship, I beg to mention item number 8. 8 and 9, Your Lordship. They are connected matters.
What is this matter about?
Prolonged suspension, Your Lordship.
Oh,
Can you accommodate me 2 weeks, Your Lordship?
the fact that you've been suspended
His Lordship.
is apparent.
His Lordship.
How you want to keep it suspended in this court
Personal difficulty, Your Lordship.
for a tea? Huh?
Lordship. Apologize, Your Lordship.
For how long?
2 weeks, Your Lordship.
The matter is it's a 2020 matter.
His Lordship.
Any DP?
Lordship, their case that a case of prolonged suspension. So far, this case of the state is that they have abandoned their services voluntarily, Your Lordship, because there are two rival claims to school, Your Lordship. One school was split, Your Lordship. They went to the school which was not recognized by the state government, Your Lordship.
Oh, I
Lordship.
thought it's a
Inquiry
service
was
matter.
duly conducted, Your Lordship. There was an order passed by the Honorable High Court, Your Lordship, asking for the state to conduct an inquiry. That has been done. That I'll place, Your Lordship, at the time of the hearing, Your Lordship.
See, like I used to say, whatever the case may be, if you have a case, you have a case. Do it. Just keep it, lingering on the matter will not serve any purpose to you or to the court or to the system.
Yes, Lordship.
On prayer made with the parties, list this matter up to.
Lordship, the state is not asking for adjournment, Your Lordship.
On prayer made by the petitioner, sorry. Matter is adjourned. Necessary after 3 weeks.
Offline.
May it please your lordship, I beg to mention item number 7. Your lordship, we pray for some more time to file our written arguments in this matter, your lordship.
No objections, my lord. Let
You are hearing for.
Your lordship, 2 weeks time, your lordship.
Oh yeah.
To file written
That has been
arguments.
heard.
Yes.
final, yes, my lord. Only to submit our summary, my lord.
You have done so.
We have not yet, my lord.
So pray made by parties.
Parties, my lord. Okay.
On pray made by parties, list is matter after 2 weeks.
Much obliged.
All right.
We'll reconvene after DB.
Daily list, item number 1.
May it please your Lord, the issue in this case, my lord, is, my lord, the judgment and order passed by learned single judge, my lord. Regarding
We have filed the deletion application if Lordship, regarding the implement of parties. It's Miss case number 36, my lord.
Deletion.
My lord, yes. On the last occasion, Lordship has given us the permission to file an application to remove the officials of the MBCL, my lord, who have been arrayed as respondents.
You filed it this morning only?
No, my lord. Last week I have filed. I filed on Wednesday.
Whom do you want to delete?
My lord, it will be respondent number 2 to 8, my lord. In the appeal, in the main appeal, my lord.
Because they are your officials of your own department.
My lord, yes. The appeal has been preferred by MBCL, my lord, and we have wrongly impleaded respondents, the officials of the MBCL also.
Yes, Mr. Datta, you are in this case.
No.
Are you here? You're not a party.
I am not objecting.
So you are representing whom?
I am representing the writ petitioner before the learned single judge.
Writ petitioner means the respondent number?
Respondent number 1.
It will be 1 now.
Respondent number 1.
1.
Who's representing respondent number 9, 10, 11?
Lordship, I'm for 9, but no notice has been served on 8.
Okay.
Yes.
No notice have been served, then you have to keep mum. Let the notice be served. So is there any requirement for issuing of notice to these 3 respondents?
Well, actually, notice on the appeal is yet to be issued.
That is, the appeal has not yet been admitted.
Yes, not yet admitted.
We are only at the threshold of the admission.
Yes.
Now what happened is, before that process is embarked, the appellant or the applicant, whatever the case may be, has come with this.
Yes, let this application be allowed, my lord. I have no.
In fact, you should have withdraw the appeal and file a fresh one.
No,
the lordship,
that will be quite.
lordship, only formal application is required, my lord. Formal application is there 2 to 8, my lord.
Yes, that we understand. That is an.
And 9, 10, 11, my lord, we will file fresh memo parties, my lord, corrected memo parties, my lord.
Yeah. So we'll deal with this application now then.
Yes, my lord.
Heard Mr. A. Kumar, Leonard E.G., assisted by Ms. Arkundi, Leonard J. who has submitted that this application has been filed with a prayer to delete the names of respondents 1 to 8 respectively from the array of parties in the main appeal, which is yet to be admitted. Two to eight, no? Accordingly, the petition is allowed. The applicant is directed to amend the cause title as far as the memo of appeal is concerned. The same will be taken up for admission on the next date. When do we do it?
Lordship can take up the appeal for admission today itself, my lord. It is already in the admission column.
Let them first correct the memo,
My lord, if we will be allowed to do the correction in the court's copy, sir, because it will be only about striking them off, my lord. You can just renumber it. It will be convenient.
You will be here today?
So it will save the time.
Or tomorrow, I mean.
I am here today, my lord.
What about tomorrow?
Tomorrow, I have some difficulty.
We can take it up tomorrow.
We'll do the necessary correction of the registry, my lord, in the meantime.
Of course, it depends on you. Since, you see, in fact, no notice has been issued on you. So, since you are here, we'll respecting you for that. But then they still have to, make a prayer for admission.
My friend can
Then
join online
notice
also.
will be issued.
My friend.
What do you suggest a date? We'll
Your Lordship can then fix it on 18th of this month.
18th is a holiday for us.
Okay. On 20th.
20th, I'm sorry, I'll not be in station.
Then on 19th.
19th, your Lordship may have it on 19th, my Lord.
19 also I may not be, because the program is not fixed. But 20 definitely I'll not be there because I have to attend program in Bhopal.
Or on 17th.
17 then.
17th.
17th, I'm having some difficulty, my Lord, because 17th I'm having difficulty, my Lord, because whole day final arguments have been fixed, my Lord, on that day, my Lord. 16th and 17th, my Lord.
Or Lordship can fix it on 13th.
17th.
In that case, 13th, my Lord. 13th, this week only, Friday.
Fine.
13th.
Please, this matter.
Also, your Lordship may have it on Monday, your Lordship, Monday,
my brother.
Sorry, 17th, my Lord.
Yeah.
Let it be tomorrow, my Lord. I'll try to see it, my Lord. Let it be
Tomorrow,
tomorrow.
your Lordship may have it tomorrow, my Lord.
My Lord,
Tomorrow, my Lord.
I may be allowed to make correction in the court's copy itself.
That's
my
what
Lord.
I've.
My Lord.
Direction is there.
Since it's coming up.
Tomorrow only, my Lord.
So tomorrow. This is matter tomorrow. For admission.
Item number 2.
Oblige.
Lordship, I too have filed a missed case for deleting the names of pro forma defendants 10 and 11.
So same order. This also come to tomorrow for. Yes, yes. Second him. Kani only with regard to 10, 11.
Item number 3.
My Lord, only one request, my Lord. I just missed it out. Instead of tomorrow, my Lord, can it be on because tomorrow there is a matter I'll have to go out of station. On 23rd, Monday.
Fine.
23rd.
We are trying to accommodate you.
Fine,
So if you say so.
23rd.
23rd.
So 23rd then.
Oblige.
May please your Lordships, my Lord, item 3. We are appealing for
the
we were the respondent. Lord, it is posted. We are not going to file any formal counter. It's a legal question. We are ready. Your Lordship may have it on 27th, my Lord. I'll come if possible and I'll try to do it. I'm in Delhi. So will your Lordship accommodate us on 27th? We'll complete the matter.
This is for admission.
My Lord, for disposal itself. In fact, when the earlier learned Chief Justice wanted to actually fixed a date for disposal itself.
Just a moment.
You know, 27th, I am having some difficulty.
There is no order for admission.
Either,
Just a moment. There's no order. So who's the appellant here?
Corporation is
I'm the appellant, my Lord.
The corporation is
How many respondents are there?
All 4 respondents, all the 4 we are appealing for. I'm appealing for all the 4.
We'll admit the appeal. We'll note that you have accepted notice.
Yes, my Lord, and fix it for hearing because the it has to be disposed of. There's a repercussions to it. Therefore, the Lordship may have it on 27th and finished off. My Lord, we want to have
27th, I am having some difficulty. Sorry, Mr. Venkataraman, I am having some difficulty. 26th is fine with me. 26th.
Okay, we'll take it on 26th. We'll take it on 26th.
26th.
Fine, 26th.
26th will complete. We'll finish the matter.
Heard, Mr.
We have also filed our written. We'll also file our written submissions before that.
We'll see.
It's a very short legal issue. It's a pure legal issue.
Heard, Mr.
I'm not in receipt of the written submission.
Yes, sir.
No, I'm yet to file. I'll give it to you. I'll give it.
How can you file a written submission before even uttering a word? Huh?
Well, I'm only saying it's right. That's why I didn't file it. Your Lordship is absolutely right. I'm guided. Your Lordship is absolutely right. That's why I didn't file it. I'm only telling my friend I'll give him a copy before I file. Sure, as it pleases you.
Alright, Mr. A. Kumar, Senior Counsel appearing for the... You're appearing as AG? Mr. Kumar?
No, Senior Counsel, my lord. This is MEP DCL, my lord.
Exactly. For the appellant. On consideration of the submission made, this appeal is admitted. As far as notice is concerned, Mr. Venkataraman. Who is with you?
Our counsel should be there.
I am assisting Mr. Venkatraman.
Mr. VVV.
Yes.
Mr. VVV Chatri has accepted notice on behalf of the respondent, and as such, no formal notice is required to be issued. On pre-made by the parties, this is matter for hearing on 26.
26.
Item number 4.
Grateful.
Please, Your Lordship. Lordship, we are supposed to file a reply in this matter, Your Lordship. Lordship, we have just received instructions, Your Lordship. I kindly pray for a week's time, Lordship.
This is an appeal.
An appeal, Your Lordship.
What reply is required?
Your Lordship, it's important, Your Lordship. Your Lordship, we have filed an affidavit in opposition, Your Lordship, pertaining. Your Lordship, we have filed a stay application, Your Lordship, in this matter, and they have filed a reply pertaining to that, Your Lordship. So, in that regard, Your Lordship, we are filing a reply.
Is there a misapplication here? There's no misapplication.
I filed the affidavit in objection.
So, do you want to file a reply to your objection?
No, they want to file.
No, that's what you have filed an objection.
Yes, I filed.
So we are talking about this stay now.
No,
application.
no, I have an objection on this time.
Exactly. This was a did or not? Where is it? Itagamis case. So we have to file. We have to pass an order in this misapplication.
No, my lord. This is I have an objection, my lord, for passing this stay order.
I'm not passing stay order. See, Mr. Dasgupta, they have filed an application for stay. You have filed objection.
No, I have filed objection in main appeal petition.
What would this stay? Are you opposing this or not? Are you opposing this application for stay?
Yes, I am opposing.
So we'll hear then. We'll hear this.
Yes, my lord.
But I don't understand where objection, what, where.
Appeal
Appeal has not been admitted. Has it been admitted?
Appeal to admitted, my lord.
You don't read the orders.
No, Your Lordship.
Then if the appeal is not admitted, how would you file? How did you file an objection?
There's an order, Your Lordship.
Order is there.
Order dated 5/8/2024, Your Lordship.
You have to.
Initially also they have raised this before the Chief Justice.
Miss, let me just try to understand. You are filing an affidavit in objection.
Yes, Your Lordship.
To the objection filed by the respondent.
Your Lordship.
That is in the main appeal.
Yes, Your Lordship.
Okay.
It's a kind of rejoinder.
Kind of rejoinder, whatever word you use. So you have not been able to file?
No, Your Lordship.
Not today?
Not today, Your
So
Lordship. A week's time, Your Lordship.
Ms. Gurung Landed Counsel, appearing on behalf of the Appellant Union of India, has submitted that the affidavit in objection should be reply.
Yes, Your Lordship.
That the reply to the objection filed by the respondent herein could not be filed today, and as such, some time is sought for the same to be filed. Pray aloud. It is in this matter, it appears that the appeal has not yet been admitted, since no formal order has been passed in this regard. Be that as it may, the parties are allowed to file the parties have been allowed to file the objection and reply or response to such objection. However, the matter will come up for admission on the next date fixed, contingent to the filing of the said reply by the appellant. As prayed for, this is matter after 1 week. So we'll not pass any order in the stay.
I will be on leave up to 25th from tomorrow.
2 weeks.
Much obliged.
Much obliged, Lordship. Item number 5.
Ravi bhai. Give me that thing now. Why you want to put this by the phone or what? I saw you are looking at the apple. No, that is fake apple. They are looking to put to the street. No, there are so many people selling the apple. 3 and 4. Hey, nobody.
Item number 2.
Lordship. Lordship, I'm coming before this Honorable Court only after almost 1 year, because earlier the accused person approached this Honorable Court, and the Annexure 4 is the order passed by this Honorable Court. Page 41. It was passed on 15/9/2023, and today is going to be almost 1 year. The court has rejected the bail thing, saying that the charges are to be argued. Charge sheet has been filed, and the case has to be argued before charge.
Commercial quantity?
It's a commercial quantity. But Lordship, the case is a little bit different. There are 7 accused. 3 accused persons, they were traveling in one vehicles, and the police were having a source informations about the person carrying the contraband items. So the source information is in page 12. It's a type copy. It says that on 19 June 2023 at 5:15 p.m. a vehicle's Tata Tigers bearing registration number so and so evaded the Naka at Nongshennings near the BM's fuel stations, tried to run over the personals at Naka, thereby endangering the lives. The vehicle is strongly suspected to be carrying the consignment. Thereafter, this vehicle was intercepted by the police, and on checking the vehicle, the police found some contraband items seized from these vehicles. But I am the persons, I was traveling in another vehicles. There's a I-20 Hyundai. The case of the prosecution is that after arresting the Jewel Das, one of the person from whom the drugs was seized, he said these drugs belongs to me. Only on the statement of the Jewel Das, I was arrested. My vehicle was checked. The police did not find any contraband items, plus any documents, any communications between them that I am the person responsible, and I have, under my instruction, he was doing the business. And the vehicle also registered in the name of Jewel Das only. My vehicle was registered in my name. They did not find. Then police, after investigations, the police has recorded the statement of the witnesses. These are the witnesses examined by the police. Police, after finding the charge sheet, police has proposed to examine 9 witnesses. So 9 witnesses in page 24. These are the witnesses listed by the police. Page 24. The first witness is B. Jarwa, MPS, and the B. Bhattacharya is the authorizing officer. Under section 41 NDPS Act, they should authorize. Then there was a witnesses complainant, number 3. Then witnesses, independent, two independent witnesses. Now witnesses, these are the witnesses, not against me. These are witnesses because the person who received the source information regarding the Jewel Das, and the authorization was given by the police to seize, to search, to conduct the search of the vehicles where the Jewel Das was traveling, where the drugs was seized. An independent witness was called to see the search, seizures, preparation of the preliminary reports, and samplings. So all the witnesses.
You go to the charge sheet has been filed, isn't it?
Charge sheet has been filed.
So what is the evidence against you in the charge sheet?
There is no evidence.
No evidence.
Except the statement which is my statement or the accused statement. I am implicating myself. Apart from suppose if the police listed these witnesses, so these are the witnesses has to prove the case against me.
Any call details report?
No, there is nothing as such against me. So these are the witnesses. Out of these 2 witnesses only examined.
What about your nexus with the accused person who has been arrested?
My nexus, simple. It is he revealed my name. The drugs which I am carrying is not belongs to me. It belongs to me. On the basis only, that is the only basis.
What is the stage of the case now?
The case is, Your Honor, Lordship, the 2 witnesses examined. Witness 1 and 2 was examined as on today. But these are the witnesses examined. There is nothing against my accused persons, and rest of the witness also I've examined their statement.
Have you annexed their deposition?
Deposition I could not annex because we are doing through the video conferencing. The witness we used to take.
When was the examination recorded?
The examination, the charge was framed on 13/2/2024. The first witness was examined on 5/7/2024, and the second witness was examined 31/7/2024.
By this time, you could have got their copies of their
copies. Yeah. See,
I would like to go through.
Yes.
See if there's anything incriminating against
me.
Whatever.
But so far, I have seen all the witnesses. They are not against me.
Yes, Mr. Shulai.
This is your lordship. Lordship, from the content of the FIR, your lordship, appears your lordship that the case involved is of commercial quantity, your lordship. Commercial quantity, and lordship, initially your lordship, they filed a bail application. This one court was pleased to consider the case on merit, your lordship. For the moment, if lordship kindly come to page page 46 at paragraph 18, your lordship. It is not the case that charges are yet to be framed, your lordship. In fact, this honorable court was pleased to reject the bail after going through the material on record, your lordship.
So this order was passed after the charge sheet has been filed?
Lordship, yes.
Yes.
Yes,
and
yes,
this
order
was
kindly
passed.
come to para 18.
Yes.
Fact and circumstances as indicated above, which is apparent, is that the main thrust of the argument is that the statement of the accused person in question, allegedly being recorded by the IO presumed under section so cannot be taken note by this court as such statement is deemed to be a confidential statement and given before a police officer and therefore held by provision so and so, which makes the statement made before the police officer inadmissible evidence. I'll come to that his statement, your lordship. The case of so and so relied upon by the petitioner has extensively dealt with this aspect of the matter, and at para so and so held that the officer who are invested with the power are police officer within the meaning of so, and consequently any confidential statement made to such officer would be barred under section 35 of the Evidence Act. In the case of so and so relied upon by the fact of the case therein are almost similar to the fact in this case, in as much as on the strength of the confession or statement made by the co-accused implicating the accused petitioner Fulshan. In that case, he was arrested. Accordingly, the Honorable Jammu and Kashmir High Court, taking note of the authority rendered in has held that irrespective of the recourse, the petitioner therein is entitled to bail. In the said case of Fulshan, the only available material found in judgment was that on the basis of the statement of the co-accused therein and so and so that he was supplied the contraband by the petitioner Fulshan was robbed in this case. In this instant case, however, the statement made was not only of the accused Joel Das, who has been given an accurate detail of how the ganja belonged to the co-accused, lordship kindly see, Karnajit Sarkar, but it is also of the statement of Karnajit Sarkar as well. That I'll point out, your lordship. In his of three accused persons who were present with him in his car, that the history of how they have procured the said contraband ganja was brought in. It was not a big statement that was made to implicate not only Joel Das but all other four accused persons whose bail application are under consent death. Then next, your lordship, the honorable Supreme Court so and so, your lordship, so and so. Then lordship, I'm taking your lordship straight away to page 58. Para 27, your lordship. This is the Ajay Kumar case, your lordship. There is in lordship
58
for 52, your lordship, at paragraph 28. Lordship, I am taking your lordship para 17 down below, your lordship.
Okay.
The quantity of ganja, whether your lordship is with me.
Yes, yes.
The quantity of ganja recovered is admittedly of commercial quantity. The High Court has not recorded any finding that the respondent accused is not primarily guilty of the offence alleged and that he is not likely to commit the same offence when enlarged on bail. Rather, his antecedents are indicative that he is a regular on. In the absence of recording of such so and so, by the we are of the opinion manifest in enlarging the accused person. Then, lordship, kindly come to para 30. This court has also keen to has to keep in mind the other accompanying factor which has led to the statement, again, which was based on the seizure of the ganja, and and the same being of commercial quantity, the provision would come into play. The charge being filed, the plaintiff have been able to argue the case on merit, therefore, as noted, the rigor of so-and-so apply in the case of the accused person in question. So, Lordship, it is a finding on merit, Your Lordship. In my humble and respectful submission, Your Lordship, in fact, this bail application is not maintainable because there is no change of circumstances, Your Lordship.
Lordship, my learned AG is saying that there is no change of circumstances. He should appreciate the bail is filed after 1 year. Going to be 1 year. The learned AG is not saying that. Why the trial is not proceeding so fast? The witnesses whom you propose to examine, whether they are saying anything against me. FSL expertise will come, will not say anything against me. Independent witness will come. Those who witness the search and seizure will not say anything against me. Complainant examine. One of the witness examine. None of the witness is saying anything against me. For that reason,
I would like to rely on the.
But this is a Lordship, a trial. I have been there in the custody for 15 months. By this time, the trial would have been completed. 9 witnesses to be examined. It takes how many months and how many months?
Mr. Kursi, the fact just a while ago you said that the 2 accused have been examined.
2 witnesses are examined.
Sorry, 2 witnesses have been examined. That is in the month of July. So,
but
July and now.
Lordship, suppose if the person is on bail, a longer date can be given. Witness can be examined any date. But when the person is under trial prisoners, a trial should be. They should expedite the trial. I definitely have a case. They may say that somebody has confessed, somebody has disclosed my name because this is an accused person. But the fact is that the factum of recovery is not there. The things are not recovered from my positions. How far the Jewel Das statement will be relied upon by them? How long they will be relying upon? Because Jewel Das is not coming in the witness box.
That is an issue of merit.
So, Lordship, is a serious
contention. The contention of the defense counsels, so far that issue is concerned, Lordship, I would like to rely on 2001 judgment of the Honorable Supreme Court, Lordship. Lordship, kindly come to paragraph 3 of that 2001 judgment, Babua versus State of Orissa. May I read it, Your Lordship? Yes. In view of section 37(1)(b) of the Act, unless there are reasonable ground for believing that the accused is not guilty of such offence and that he is not likely to commit any offence while on bail alone, will entitle him to a bail. In the present case, the plaintiff attempted to secure bail on various grounds but failed. But those reasons would be insignificant if we bear in mind the scope of section 37(1)(b) of the Act. At this stage of the case, all that could be seen is whether the statement made on behalf of the prosecuting witness will result in conviction of the petitioner or not. At this juncture, we cannot say that the accused is not guilty of the offence if the allegation made in the charge are established. Nor can we say that the evidence having not been completely adduced before the court that there are no ground to hold that he is not guilty of such offence. The other aspect to be borne in mind is that the liberty of a citizen has got to be balanced with the interests of the society. In case where narcotic drugs and psychotropic substances are involved, the accused would indulge in activities which are lethal to the society. Therefore, it would certainly be in the interest of the society to keep such person behind bars during the pendency of the proceeding before the court. Then, Lordship, another observation, Your Lordship, in bail application 22, where Lordship was the author of that order. Lordship, kindly come to page 18 of that order dated 31/7/2023 in bail application number 22 of 2023, Your Lordship. Para 18, Your Lordship.
Yes.
In the case of Indresh Kumar, the Honorable Supreme Court has cited the case of so-and-so, more particular at para 2 of the same, which read as follows. There is no doubt that the crime of the grant or denial of bail is entirely the discretion of the judge considering a case, but even so, the exercise of judicial discretion has been circumscribed by a large number of decisions rendered by this court and by every high court in the country. Yet occasionally there is a necessity to introspect whether denying bail to an accused person is the right thing to do so on the fact and in the circumstances of the case. Taking a cue from this court is reminded of a remark which the scourge of drugs yield disastrous consequences on the health of young people, the well-being of the family, the spread of crime, and the destruction of economies by the financial flow of obscure origin. The above remark is true in the society that we are now living, where the menace of drug is threatening to destroy life and society. Indeed, young people are most vulnerable to this threat, and many a time have been seen to fall prey to the same. It is incumbent upon this as well as the court to combat this menace in whatever possible way. And although due process of law has to be followed in drugs-related case, the investigating agency and the court have to be given wide latitude in napping and or bring in any possible accused to book, Your Lordship. Then another remark, Your Lordship, from the Honorable Rajasthan High Court, Your Lordship. Lordship, kindly, Rajasthan High Court, Your Lordship, the Honorable Rajasthan High Court, Your Lordship. If Lordship kindly come to para 29 of that judgment. May I read it, Your Lordship? May I read it,
Yes,
Lordship?
please.
Drug abuse has taken its toll in almost all the district of Rajasthan. Your Lordship, I may pause here, Your Lordship. If the statement of the Honorable Minister, Your Lordship, in the assembly, recent assembly session, Your Lordship, we have 3 lakh drug addicts in the state, Your Lordship. 3 lakh drug addicts in the state, Your Lordship. That was the statement made by the Honorable Minister of Social Welfare, Your Lordship, in the floor of the assembly, Your Lordship. The addicts primarily belong to a youth age. Lordship, kindly see, the high rate of drug consumption is leading to issues like illegal trade, drug trafficking, and smuggling. The problem of drug addiction has a significant bearing on drug trafficking, which has become a significant challenge for the government and social reformers. The NCB report that the main internal factor of drug trafficking in India is the illicit cultivation of opium, poppy, and cannabis. Also, the diversion from illicit opium sources to illegal opium production is a major concern. In the trend of 2000, Rajasthan is among the 3 major states, along with Uttar Pradesh and Madhya Pradesh, from where the opium is trafficked to other parts of the country. Young Indians addicted to drugs are spoiling their life. Drug addiction is the worst kind of addiction, and it causes numerous mental and physical ailments, and such youth go often into depression. In order to cope with stress and depression, they try to consume more drugs and keep spiraling around and are never able to leave this addiction. They lose their sense of control and become vulnerable, and many of them commit suicide or get involved in different kinds of criminal activities. This is what happened in the state, Your Lordship. Drug abuse has a direct impact on social and economic aspect of the nation. The impact of drug is realized in workplace, family, and the society. Its result in violence at home and gang wars in cities, increased crime, and even stresses the public health system. And we find young mass addicted to drug will lead to unsafe life. Addiction not only break the family harmony, but also put high economic burden on the society. The economic impact due to drug abuse is immeasurable. According to the UNDCP report, the economic effect of drug abuse can be measured into terms cost of government drug enforcement policies and the loss of human productivity, such as lost wages and decreased production that result from illness and premature death related to drugs. There are many hidden costs relating to disturbance in social life, wastage of young energy. One can notice apparent rapid changes in societal alignment owing to the reduced family and community cohesiveness, increased unemployment and underemployment, economic and social marginalization, and increased crime. Lordship, kindly see the observation of the
Point taken.
Lordship, for the purpose of bail, Lordship, kindly come to page 28. The statement made by the accused, Your Lordship.
28
of the bail application, Your Lordship. For the purpose of bail, Your Lordship, this is admissible, Your Lordship. So far, for the purpose of bail, can you see his statement, Your Lordship?
Yes.
My name is so-and-so, I purchase the contraband ganja.
We are reading statement.
Lordship, at page 28, the statement of the bail applicant, Your Lordship.
Karnajit.
Karnajit is the applicant.
Who is the applicant?
Yeah, prisoner is the brother of the accused.
Who's the accused?
Two accused are there. One is a Karnajit and another is
the bail applicant, bail petitioner is the brother, Your Lordship, the cousin brother of
Karnajit
the
and Sanjit Sarkar.
Okay, Karnajit and Sanjit.
These are the two persons approached.
Yes.
See, kindly see, Your Lordship, the statement first of Karnajit, Your Lordship. I purchased the contraband ganja from one tribal fellow name not known by me at Sanumara. That means this is a place somewhere in Tripura, if I'm not mistaken, if I'm not wrong, Your Lordship. I contacted Joel Das, Sri so-and-so for carrying the said contraband in Sirampur with the vehicles of Sri so-and-so, Tata Tikor. I promised to pay all of them. And up and down fuel and fooding expenditure thereafter went to and loaded the contraband so myself along with so left Somara to deliver the said contraband to one person by the name of Nitesh having contact number so in my in my vehicle Hyundai number. All of them reached Silchar by evening and halted in one hotel in Silchar. On at around we left Silchar and reached Meghalaya at 2 p.m. when the road blockade was clear. My vehicle was leading in front and followed by Jewel Das. On reaching at one police Naka checking, my vehicle was stopped by police for checking, and after 1 hour or so, the police team allowed my vehicle. But in the meantime, Jewel Das vehicle along with other two occupants fled away from the police point, but were seized by the police vehicle. See, Lordship, how he accomplice tried to flee, Lordship. My vehicle was detained again at another checkpoint at Kong after crossing Cleariat and brought me Sri Sanjit Ka Tutan Sarkar so-and-so with vehicle to Cleariat. On being detained and brought to I saw that so-and-so along with their vehicle have already been detained by the police. After police conducted search and checking of my but nothing could be found inside. But on checking and search by police the vehicle of so-and-so, the police detected found contraband loaded in boot which is fully loaded with contraband. I am also to say that ganja were purchased by me at the rate of so-and-so, and paid to the unknown tribal fellow at rupees so-and-so, 5 lakhs so-and-so, only which we are collectively sponsored by all 5 of us. Shri Joel Das, Sanit Sarkar, Tutan Sarkar, Sujit Sarkar, but the main sponsor is Joel Dar, and me, Your Lordship. See, Your Lordship. For the determination of bail, Your Lordship, this statement are very crucial, Your Lordship.
The prosecution has cited the judgment. These cases cannot be decided on the basis of the judgment cited. It's very emotional kind of judgment. The facts remains that the 9th witness the prosecution has proposed to examine. He's not saying anything about the evidence of the prosecution. The first witness which the prosecution proposed to examine is the informant who received the informations. And the second witness is the authorized officers. Under section 41, he has to give the authorization to go for search and seizures. Second witness is the complainant. After all the formalities are completed, then he has filed an FIR with the police that these are the formalities completed. Now there is other witnesses, police witnesses, with regard to the recovery. 2 independent witnesses was informed by the police to witness the search and seizures. And there is a FSL again. So what are the evidence collected by the police against me? Apart from my statement, because my statement is a statement, it can be acted upon only if the statement is recorded under section 164 CRPC. But since it is not recorded under section 164 CRPC, and I have been there for 15 months, so I am seeking a justice why I am there in the custody for 15 months when the prosecution could not bring any evidence, any witness against me who can depose against me before the court. You're saying that my statement cannot be acted upon before the court of law unless it is recorded in section 164. So for the reason the bail is filed last year's, it was filed on 15/9/2023. Now I filed this application with a very specific amendment made in the bail application also. Number 9 in para that the London trial court framed the charge against the accused, but the trial is moving at a very slow pace. As on today, 2 witnesses have been examined by the prosecution. As on date, the witness examined so far did not utter anything against the accused persons. Number 10, I said it may be submitted herein that the accused persons were arrested on 19/6/2023 by the police. The charge sheet was filed on 20th/7/2023, but the trial is yet to be concluded. Now it is more than 15 months the accused person have been in custody. Therefore, the serious miscarriage of justice have been occasions due to delay in trial. Further incarceration of accused have name would be violation of the article of the accused person enshrined under Article 20 of Constitution of India. I also need the trial to be expedited. I also need that I should come out from the jail. I can prove my innocence before the court. But in the absence of any recovery of any contraband goods or any incriminating documents connecting me with these contraband goods, prosecution cannot read my statement. Just reading my statement and saying you are not entitled to get the bail. But what the prosecution has done as on today, they have not done anything. They have not brought any witness. They have to heavily rely on the witnesses whom they propose to examine before the trial. Had they saying anything, if they are saying anything against me, definitely I am not entitled to get the bail. But they are not saying anything against me. These are the witnesses not connected anywhere with me that I am involved in this case. I have given the list of the witnesses. If prosecution can read out the statement of the witnesses and can say that there is a clinching evidence against me and I am not entitled to get the bail and the prosecution is going to succeed the case against me, definitely I am not entitled to get the bail. But why are keeping me for 15 months inside the jail and no trial is witnesses examine and examine witness also did not say anything and the rest of the witness also not against me. So for that reason, Lordship, I have come before this court after almost 1 year.
See, at the outset, I have asked you whether you have copy of those.
Lordship, I may be given some time. I will try to procure the copy.
Let me go through those.
Yes.
Depositions.
Okay, Lordship.
And you would also have to satisfy this court as to what would imply change of circumstances.
Change of circumstances.
Well, as far as this court is concerned, the trial is proceeding.
Trial is proceeding?
So, change of circumstances at this point of time would mean if there is something drastic that has happened in between that has, that has caused prejudice to you.
Prejudice.
So, if you can prove that.
Okay, I'll try.
Otherwise, what we can do is, in normal course, we'll wait for the completion of the trial.
Conclusion of the trial.
Whatever the case may be, if you are found innocent, so be it.
But Lordship, that's what I want that.
But the fact remains, Mr. Qureshi, not only this court, but even the apex court would say this, that in the teeth of section 37. So if the court at the first instance, even when the first bail application was moved, finds that there is no ground to show that you are innocent.
But not sure how to overcome this 37. Then again, this Honorable Supreme Court has said that in case of delay of trial, that 37 will not be the stringent condition laid down.
Then you also have to impress upon this court as to how long would be delay. Would it be 1 month, or would it be 5 years, or would it be 2 months, or 1 year?
That is the one of the ground.
If you can satisfy this court on that point, then
I'll try to procure the copy.
How? When?
2 weeks.
2 weeks.
Because
Lordship, yes.
From the credit.
Heard Mr. M.F. Qureshi, learned counsel for the petitioner. Also heard Mr. N.D. Shulai, learned AAG, appearing for the state respondent. This is an application for grant of bail on behalf of the accused person, Sri Karnajit Sarkar and Sri Sanjit Sarkar, who are undergoing trial in, what is the case number?
Criminal NDPS number 25 of 2023, Your Lordship.
Criminal NDPS number 25 of 2023.
NDPS bracket.
Under section, IT section. However, Mr. Qureshi has also some in course of submission. This court has been informed that the trial is proceeding and two prosecution witnesses have been examined. To better appreciate the stand of the respective parties, this court would deem it proper for the deposition of the said witnesses to be produced. However, copies of such deposition is not on record. The learned counsel for the petitioner has submitted that he may be allowed to produce the said deposition, copies of the said deposition on the next date. As prayed for, this is matter after 2 weeks.
Oblige, Your Lordship.
Item number 3.
May it please Your Lordship. Lordship, in this matter, I need some more time, Your Lordship. The affidavit is being drafted, Your Lordship. Kindly allow us at least 3 weeks time, Your Lordship, another 3 weeks time. This is that remission, Your Lordship.
Okay.
Lordship.
I think the Supreme Court in this matter has left it to the to the wisdom of the state government for as far as commission is concerned.
Lordship, subsequent order, I say if there is a pending application before the High Court, Your Lordship, that has to be disposed of, Your Lordship, on its own merit, Your Lordship. So 3 weeks time, kindly allow us, Your Lordship.
None appears for the petitioner. Mr. Andishwara, Learned AAG, has sought for time to file the counter affidavit. Accordingly, as prayed for, this is matter after 3 weeks.
Apply, Your Lordship.
Item number 4.
Good afternoon, Lordship.
Yes.
Lordship, this is a bail application preferred on behalf of an accused who is undergoing custody in Nongpo. Commercial quantity, of course.
My lord, before my friend starts, as per the last order, my lord, the state was directed to produce the case diary, my lord. But so far I have not received, my lord. But that apart, my lord, the case diary is there along with the petition. It is there, my lord.
I annex the charge sheet.
Charge sheet is there.
Charges frame?
No, Your Lordship. We are at the stage of CC. We have been at the stage of CC for quite some time. But the present status is consolidation of charges, Your Lordship. If I may, Your Lordship.
How long have you been in custody?
Lordship, 1 year, 2 months. Exact, precise number of days I'll not be able to say, but 1st of July 2023. So that's approximately more than 1 year, 2 months.
This is the first application?
Before yourself, yes. Before the High Court, yes.
See, Mr. Guru, this is the charge sheet. This is a copy of the charge sheet that is filed with you. What is required is the case diary.
Well,
because in the case diary you will find the process and progress of investigation. How many witnesses are being examined? What was what led to the investigating officer to come to the conclusion that charges are required to be framed and all those things. Otherwise, here you will just find a simple line to say that prima facie there is a well-established case against the accused and so on and so forth.
I'm praying for 4 days time, my lord.
Mr. Yaraf, one thing you have to see,
yes,
be prepared is the rigors of Section 37.
Absolutely.
Until and unless this court is convinced of the innocence of the accused.
Right.
I mean, we are also bound by the
37.
by the law. How long?
4 days, man.
So Friday.
On Friday?
On Friday.
Mr. Argun, Leonard G. appearing for the state respondent has sought for time to file the copy of the case diary, which could not be produced today. The prayer not being objected to by the petitioner, the same is allowed. As prayed for, this is matter on 13th.
Value, please.
Deeply appreciate.
Have a good day.
Item number 5.
The written argument has been filed, my lord.
Right. We have not filed. All parties are filed.
Not filed, my lord.
Both matters. And counsel, respective parties have submitted that the written argument on their behalf has been filed. Accordingly, this matter is now reserved for judgment.
Well, this is with regard to maintainability, my lord.
Yes, maintainability. I think that is the direction of the Supreme Court.
Your Lordship, I just have one request. Your Lordship, may the conducting counsel, Mr. K.C. Gautam, his appearance may be reflected on the order sheet.
Why?
On the judgment, Your Lordship.
What about you?
No, for today's date, Your Lordship. Just for today's order. He's the main conducting counsel for CRP number 28. He's on legs, Your Lordship, in courtroom number 1. That's why.
What difference does it make?
Your Lordship, I was instructed to.
I'm not recording any of his submission, your submission, or anybody's submission for that matter. It's just a question of formality that you have to present your written argument, and that's done.
My lord, another humble request, my lord. Although the written argument is filed, my lord, in the meantime, my lord may grant us a day or two's time. If we get any judgments, my lord, I'll just forward it to you.
You can do that. Along him too. Can mom talk to Geneva? Number 1. We'll do it.
Obliged, my lord. Obliged, my lord.
Item number 6. My lord, we have filed the written submission, my lord, in the miss case, my lord.
State is not filing any.
State is not filing any. State.
You have filed yours.
Yes,
yes,
my
Miss Adata Leonard Counsel for the respondent, the Mokani Hakamis case money, has submitted that the written argument on behalf of the said respondent has been filed. Accordingly, the order in this miscase is reserved. Can you make case, this is matter to 2 weeks.
Right.